A business owner signs a letter of intent. Right at the top in plain language it reads, "This document is non-binding. The parties are not obligated to complete the transaction." Having read that line, they relax. They stop reading as carefully as they should. 3 weeks later, a competing buyer comes and makes a better offer, and the seller would love to take them up on it. They can't. Because buried in that non-binding letter of intent was a binding exclusivity clause. This provision has committed them to negotiate with that first buyer exclusively for 60 days. They're bound. That better offer has to wait and maybe walk away. This happens all the time. I'm Chad Graham, an Alberta corporate commercial lawyer, and this is episode 6 of From Build to Sold. Today we're going to dive deep into LOIs, letters of intent, sometimes called a term sheet or a memorandum of understanding. Whatever it's called, though, it's the document that sets the framework for everything that follows in your sale. And it's the document that most sellers sign with the least amount of legal scrutiny. This is a mistake I'm going to help you not to make. So what is a letter of intent? Well, it's a document signed by the buyer and seller that records the agreed key terms of a proposed transaction before the definitive purchase agreement is negotiated and signed. It is not the purchase agreement. It is not the final contract. But it is the foundation upon which the final contract will be built. And the terms you agree to in the LOI will shape everything in the negotiation that follows. Now think of it this way. The LOI is where the deal is set. The purchase agreement is where it is documented. If you give away too much ground on the LOI, you'll spend the rest of the transaction trying to claw it back. And a buyer and their team will have already moved on and not want to do this. Here's the critical concept where most sellers get it a little wrong. Most LOIs are indeed non-binding as far as the obligation to actually complete the deal. Neither party is legally required to close the transaction. Either side, during the due diligence or after in the negotiation, can walk away. The deal is not done when the LOI is signed. However, and this is the part that matters, certain provisions within the LOI are binding upon signature. They are enforceable the moment the ink is dry, regardless of what happens in the rest of the transaction. The confusion, overall, between non-binding nature of the document and the binding nature of these specific provisions is exactly where the unwary get caught. Here's things that are typically non-binding. The purchase price, the payment terms, the proposed sales structure, asset or share, the conditions that need to be satisfied before closing, the representations and warranties the parties will make, and the target closing date. All of these are subject to negotiation in the definitive agreement. The LOI records an intention and a framework, but it doesn't lock them in. Here's the sections that are typically binding. First, the exclusivity one, the one I started this video out with. It causes the most real-world pain, so I'll give you a couple of details. Exclusivity provisions commit the seller not to solicit, entertain, or negotiate with any other prospective buyer for a defined period, typically 30 to 90 days. During that period, you are off the market. You cannot accept a competing offer, even if one arrives unsolicited. You cannot continue discussions with someone you've been talking to previously. This provision is binding the moment you sign the LOI. It doesn't wait for any triggering mechanism. You are bound, but your buyer is not. Their only obligation is to negotiate with you in good faith, and that's a relatively low bar. So what you're negotiating on this provision is time. The shorter the exclusivity period, the less risk you carry. But 30 days is probably too aggressive. Most buyers need longer for meaningful due diligence. 60 days can be a reasonable commercial period. 90 days can feel long unless your business is genuinely complex, and then you want to make sure that you allow it. One thing you really want to watch for in here are automatic renewal provisions that let the buyer trigger a second exclusivity period. Apart from that, there's a couple more that are important to you. Confidentiality. The LOI itself, its existence, its terms, and the facts discussed in it are confidential. This is generally appropriate and it protects both parties. but understand what you're agreeing to. You may not be able to disclose that you're even in discussions for sale, even to key advisors, without their consent. Read the provisions carefully. Costs. Some LOIs contain provisions allocating provision of costs if the deal falls apart. For example, if the seller terminates the deal after due diligence has begun, the buyer may have a claim to recoup due diligence costs. Well, let's go through the commercial terms a little bit, even though they're not binding, because they're pretty important anyway. And here's why. They can matter enormously. Once you've signed an LOI, you're in a relationship with this buyer. You've given them exclusivity. They're spending money, on due diligence and legal fees. The emotional and financial investment on both sides begins to create a momentum towards closing. And that momentum is a force. It's a force that tends to work against sellers who try to renegotiate terms that were dealt with in the LOI. In practice, the LOI sets a really firm anchor. Buyers treat it as their baseline. And every deviation from the LOI and the purchase agreement is a renegotiation in their eyes. They'll resist it, even if technically they have no right to those initial terms. That means if you give away too much in the LOI, it's very difficult to claw it back. One area I see all the time is confusion around the purchase price formulas that seek to get around a fixed price. Many express it as, for example, one I saw recently, 4 times 12 months EBITDA, that's earnings before interest, taxes, depreciation, and amortization, calculated at closing. This sounds clean and objective, but it's not. What does EBITDA mean in this context? Whose accounting methodology applies? Are there add backs included? Is the trailing 12 months counted or the previous calendar year? What happens if the calculation produces a different number than both parties expected? These are not hypothetical disputes. They are disputes that actually happen between the LOI signing and closing. So you want to define the formula precisely or don't agree to a formula at all. A fixed purchase price is cleaner and simpler for the seller. In episode 4, I introduced working capital. I want to go back to that here because the LOI is the moment to define it. If the LOI is silent on working capital or simply says the purchase price will be adjusted for working capital at closing, without defining what normal working capital looks like, you've created a dispute waiting to happen. The buyer's accountant will calculate a working capital peg. Their number will serve their interests. Your number would have served yours. Whoever defines it first takes the advantage. So you want to define working capital in that LOI or agree on a methodology for coming to it. This is not a technical issue to be sorted out later. It's a negotiating point with real dollar consequences. Sales structure is huge. Asset versus share. If it's not agreed on in the LOI, you are exposed. We're going to cover this more fully in the next episode, episode 7. But let me give you the one-liner here. Sellers typically prefer a share sale, and buyers often prefer an asset sale. And the reason is tax and risk mitigation. A share sale allows the seller to potentially access lifetime capital gains exemption. An asset sale generally does not. If a buyer inserts an LOI with asset sale as the proposed structure and you sign it, you've surrendered a negotiating position that may be worth hundreds of thousands of dollars in after-tax proceeds. Don't let the structure question drift into the purchase agreement negotiation unresolved. LOIs are enforceable in Alberta by common law. There's no specific Alberta statute governing letters of intent in commercial transactions. That means it's not always clear-cut in various areas. Courts will look at specific language, for example, in a document to determine which provisions the parties intend to be binding and which they didn't. Ambiguous language is not construed in your favor. It creates uncertainty, and uncertainty costs money to resolve. 2 specific pitfalls that I've seen are worth mentioning. First is the error of making an agreement to agree. Courts will generally not enforce a provision that says the parties will agree on particular terms later. For example, if the LOI says the working capital peg will be agreed to by the parties prior to closing, that provision is probably unenforceable. Agree on it in the LOI or accept that it may not be agreed to at all. Second, there is something called the implied obligation of good faith. Alberta courts recognize a duty of honest performance in contracts. This doesn't mean the buyer or the seller are required to close, but it means that conduct during the LOI period that is dishonest or designed to exploit may have legal consequences. This is an area of developing case law in Canada and worth understanding if a dispute arises. All right, here's a quick how-to when you enter into an LOI negotiation. When a buyer presents you with an LOI, do not react immediately. Take a little bit of time. Do not negotiate informally by email before your lawyer has reviewed it. Do not agree to anything verbally that you haven't seen in writing. Give your LOI to your lawyer, have a conversation about terms, identify where you and the buyer are aligned, where you need to push back, and where you're willing to concede. Then respond in writing with a clear, organized counterproposal. A good counterproposal is everything. It focuses the buyer's intention on the issues that actually matter to you. For example, the things we've talked about, the exclusivity period, the price formula, the working capital definition, and share structure. Pick your battles. A seller who redlines every provision in an LOI shows they're inexperienced and create friction. A seller who pushes back firmly, but only on certain issues, indicates they understand the deal. Here's the getting to yes principle applied to an LOI. You're not trying to win every point. You're trying to close your deal at a fair price on terms that protect you. These are different objectives, so keep them distinct. The LOI is the document that most sellers underestimate and that most buyers have seen dozens of times. That asymmetry of experience is exactly why legal counsel at the LOI stage is not optional. It's the single highest return legal investment you will make in the entire transaction. A few $100s of legal fees at the LOI stage can protect hundreds of thousands of dollars at closing. I've seen it. The math is straightforward. Now, episode 7 will cover the key question that LOIs often leave unresolved and that your lawyer absolutely should address with you. Asset sale versus share sale. It's one of the most consequential structural decisions in any business deal. And buyers and sellers often, although not always, have directly opposing interests. That's next. So if you're in the process of reviewing an LOI or one has just landed in your inbox and you're not quite sure where to start, book a consultation with me by link or by going to chadgrahamlaw.com. We offer LOI review and negotiation support, and we will tell you plainly what matters and what does not. I'm Chad Graham. Don't sign that LOI until you've talked to your lawyer and perhaps watched episode 7.